You live in Florida. You have a medical marijuana card, totally legitimate, from a licensed doctor, everything by the book, and up to date with the state. Before your cruise out of Miami, you stopped at a dispensary in Fort Lauderdale and picked up some edibles for the trip. You have the receipt. You followed every rule Florida has. You're standing at Port Miami, bags on the belt, excited for vacation. And then a handler says something quiet. A K9 sits down next to your bag, and you think, this doesn't apply to me. I'm legal. Here's the thing. That card in your wallet, that receipt from the dispensary, none of it matters where you're standing right now. Because the moment you walked into that terminal, you stepped off Florida law and onto federal law. And on a cruise ship, that means federal drug charges, not a ticket, not confiscation and a slap on the wrist. Federal court, federal mandatory minimums, a federal conviction that follows you for the rest of your life. I'm Adam Rossen. I'm a Florida criminal defense attorney, and I see this confusion all the time, especially since Amendment 3 was on the 2024 ballot and came within 4 points of passing, along with Florida's widespread medical marijuana access. People think Florida is basically legal, but even if it were fully legal tomorrow, it wouldn't matter where you're about to go. I'm going to explain exactly why and what's actually at stake. By the end of this video, you're going to know 5 things. 1, why cruise ships operate under a completely different legal system than Florida and when that switch happens. 2, why your medical marijuana card, your dispensary receipt, or your home state's recreational law means nothing the moment you walk into that terminal. 3, what federal drug charges actually look like, because they are not the same animal as state charges. 4, why a foreign port adds a completely separate layer of legal risk that most people never even think about. And 5, why Florida state law isn't entirely out of the picture either, and why where you boarded the ship matters more than you'd think. If this is already sounding relevant to your situation, make sure you like and save this video. This is one of those things where knowing it in advance is the only protection you have. Here's the first thing people don't understand. It doesn't start when the ship leaves the harbor. It starts when you walk through the terminal door. U.S. cruise terminals, Port Miami, Port Everglades in Fort Lauderdale, Port of Palm Beach, those are federal facilities. Customs and Border Protection runs them. The K9 units working those terminals are federal assets. The moment you step into that building, you've left state jurisdiction, and federal law is what applies. Once the ship leaves port, it moves into federal maritime waters. In international waters, anything past 12 nautical miles from shore, it's Title 18 of the U.S. Code that governs, not Florida statute, not the law of wherever you flew in from, federal maritime law. And here's what that means for cannabis specifically. The Federal Controlled Substances Act still classifies it as a Schedule I narcotic, same category as heroin. No state has changed that. No dispensary receipt changes that. No card changes that. I've heard from people who flew into Miami from California where recreational cannabis has been fully legal for years. They brought products purchased from a licensed dispensary legally with a valid California medical card. Then they got stopped at Port Canaveral. The California card did not help. My state is legal did not help because their state's law had zero jurisdiction in a federal terminal. Stop right there and let that land. The dispensary where you legally purchase something is operating under state law. The terminal where you're trying to board, federal. Those are 2 separate legal universes and they do not speak to each other. Let me address this directly because I know what people are thinking, but I have a Florida medical marijuana card. I have documentation. I'm a patient. Here's what the prosecutors actually said after they arrested approximately 25 passengers trying to board a Norwegian cruise out of Port Canaveral. The products they found included THC edibles, cannabis oil vaping pens, and gummies. Several passengers presented their out-of-state medical marijuana cards when they were stopped. A local felony intake chief was quoted directly. "We have seen some individuals who have medical marijuana cards, but most don't try to present the card." And why don't they try? Because it doesn't change anything. The charges were still filed. Your Florida MMJ card is a defense to a Florida state charge. It has no legal effect in a federal drug-free zone. The federal government does not recognize state medical marijuana programs, period. And here's where it gets even more surprising. It's not just the obvious stuff that gets people caught. A nurse from Texas was permanently banned from Carnival Cruise Line after port officials found CBD gummies in her luggage, not THC. CBD, which is federally legal if it's under 0.3% THC. But canine dogs aren't pharmaceutical testing labs. They react. And when they react, the process begins, and suddenly you are being screened by CBP and explaining yourself to federal agents. The safest rule is the simplest one. If it came from a dispensary, if it contains any form of cannabis or THC, including Delta 8 and hemp derived products, leave it at home. None of those products have ever been found to be protected at a cruise terminal, and the risk is federal charges, not a fine. Here's where I need people to really listen, because federal drug charges sounds like a phrase, but what it means in practice is a completely different experience from anything that happens in Florida state court. In January 2024, two passengers were arrested at Port Miami trying to board the Norwegian Joy headed to Southampton, England. Department of Homeland Security agents found 112 vacuum-sealed bags of marijuana in their luggage, more than 150 pounds total. The charges: conspiracy to distribute a controlled substance, attempted exportation of a controlled substance, and possession with intent to distribute. Federal charges, federal court, federal judge. Now, I'm not saying your situation is 150 pounds of vacuum sealed bags, but here's the point. In federal court, the rules are different. In Florida state court, we have things like deferred prosecution agreements, drug court diversion, adjudication withheld for first time offenders. Those pathways exist because Florida built them in. Federal court doesn't have most of them. Federal judges follow federal sentencing guidelines. Federal mandatory minimums, when they apply, are not negotiable. Not by the judge, not by the prosecutor, not by your attorney. You serve the time. Federal drug trafficking charges are based on weight thresholds. And for cannabis specifically, here's what those numbers look like. Under federal law, once you hit 100 kilograms, that's about 220 pounds. You're looking at a mandatory minimum sentence of 5 years in federal prison. Not 5 years possible, 5 years minimum. A judge cannot go below it. Above 1,000 kilograms, that mandatory minimum jumps to 10 years. And even below those thresholds, federal distribution charges can carry up to 20 years. Now, those are the cannabis numbers. Different substances have completely different and often much lower thresholds. Cocaine, fentanyl, MDMA, the numbers that trigger mandatory minimums are significantly smaller. The exact charges also depend on the specific facts, what the prosecutor decides to file, and how the evidence is packaged, which is exactly the point. Once you're in federal court, those variables are in the prosecutor's hands, not yours. This isn't state court with a plea deal and probation and move on with your life. Federal drug convictions carry consequences that follow you: employment, housing, federal financial aid, professional licenses, immigration status, everything.